Hello everyone, welcome to our latest webinar. This is now our fourth webinar. I do hope that everyone can hear me okay. I know that whenever I'm joining these events that sometimes I'm having to fiddle about with the sound on my computer for some time. So if you are having any problems hearing me, if you're seeing my lips move but no sound coming out, then please do just pop a little note on the screen on the right hand side if you're having any difficulty. Now, as I said, this is our fourth webinar. We've done a couple of webinars on furlough and last week on an update on employment law. So this is another one of our series of updates that we're providing to people. And this one obviously is on restrictive covenants and confidentiality. So a slightly more an older topic, so to speak. This has obviously been around for quite some time, and is something that lots of us have seen, lots of us generally know about, but there are a few myths that we need to deal with, and also just want to get into obviously all of the issues in relation to the use of these restrictions. But before we get into the detail of the actual presentation today, what I do want to do is just let you know that we are posting these updates also on our YouTube channel, which we've now got, and there is also, in the last couple of days, I've put a short update on the channel about the latest that's been happening in furlough, so please do feel free to check that out. I'll also be making the slide deck, of course, available to everyone after the event, so I will email that out to you. I don't have a large pack of information to give you, though, other than the slides, because as you'll see as we get through this topic, that actually there's a lot of ifs and buts, and this isn't really a case of having template clauses or template letters that you can use in all circumstances, in all instances, because this really does have to be tailored. If you're going to do it properly anyway, if you want to have these restrictions binding and reliable in future. Okay, so as I said, on the right hand side of your screen, there should be the option for you to ask some questions if you want to. It might be that I don't get around to all of them whilst I'm actually delivering the webinar, but I certainly will when I'm sending the slides out at a later point. I'll make sure that if there are any questions that have been asked, that I'll pick those up and I'll make sure that they are answered then. So apologies if I don't answer them during the session. I'll certainly try to, but if I don't do, we'll pick it up at a later point. Okay, so that's the sort of introductions over. Now, in terms of the agenda for today, so we're going to run through until 11 o'clock, and these are the topics that we're going to be covering. So, of course, as you'll see in the middle of this, that we've got all of the information about all the topic that we're going to be covering in relation to confidential information and restrictive covenants. First of all, we're going to be dealing with something that's called duty of fidelity, which you may or may not have come across, but I want to talk about it in a little bit of detail, because it actually deals with essentially what you can do if you don't have these terms within your contract. So this is the sort of, well, if you haven't got it, then you do have a little bit of protection, and this is what it is, and this is what it looks like. We'll have a look at some contractual terms that we can use to sort of boost that duty of fidelity before we then get into the terms that you do want to be including in your contracts in relation to confidential information and, of course, restrictive covenants, and then how you enforce it and whether you can enforce it or not. So we'll be having a look through all of that. So that's the next hour. So hopefully that's what you're expecting. Now, in terms of the duty of fidelity, so like I said, this is all to do with what if your contractor simply doesn't say anything. So you're in a situation where you've got an employee who's going off to a competition or a competitor, or is taking your customers. What can you do about it under this duty of fidelity? Well, not a huge amount, but let's see what we have got. So in relation to the duty of fidelity, it's difficult to pin down what the duty of fidelity actually is. It is uncertain because, I mean, as you can see here, it's all about the duty that the employee owes to their employer. This duty of fidelity and mutual trust and confidence. Now, I'm sure we've probably all heard of mutual trust and confidence. It's something that employees generally use to their advantage when they're looking at the constructive dismissal claim. So it's usually the bit that's relied upon by employees when they are pursuing constructive unfair dismissal claims. It's that breach of mutual trust and confidence. You haven't treated me in an appropriate way. You've fundamentally undermined the mutual trust and confidence in the relationship. So that's from the employee's point of view, but it is a mutual trust and confidence. And so therefore it is something that can be used by the employer as well. And so it actually does require the employee to take into consideration the interests of their employer. Now, the extent to which you can rely upon this is really determined very much on a case-by-case basis. It depends upon the employee. It depends upon the role of the employee. It depends upon the seniority of the employee. And so it really is going to vary depending upon the influence that the employee has and the control that they have. And of course, if you've got someone who is higher up in the organization, who does have that influence, who does have that control, then of course, hopefully you would have those clauses in the contract in any event. But if you don't, then what the duty of fidelity does address is, particularly in relation to what we're looking at in relation to restrictions and competition, it does relate to competition. It relates to preparations to actually compete with the employer. It relates to the use of confidential information. And in particular, it's these two middle bullet points, the competition, the preparations to compete, and the use of confidential information that are generally the most important aspects of a duty of fidelity in the absence of other clauses. But the slight problem that we've got with it, I say slight problem, it's actually a quite significant problem, which is why you need to have specific clauses, is that whilst it runs during employment, it largely ceases upon termination. Now, there are some arguments in which, and in some instances where it can continue after termination, but that's really quite difficult. Now, as you can see here, I've also mentioned something called fiduciary duties. And I'm not obviously wishing to overcomplicate things, but fiduciary duties is something that as a senior employee, it then provides even greater significant protection for you as an employer. So when we're having a look at fidelity and fiduciary, a fiduciary duty is something that is of a much higher level. So everyone has a duty of fidelity. Every employee has a duty of fidelity. But only senior employees are going to have a fiduciary duty placed upon them. And particularly that's going to be directors. So statutory directors automatically have a fiduciary duty placed upon them as part of their statutory duties as a director. But I'm talking about statutory directors there, so those that are listed on Companies House. If you've simply got the term director in your job title, then that does indicate you're a senior employee, and therefore you may have some fiduciary duties placed upon you, but not automatically. So what it does is you've got to have a look at what the job is. So in a similar way to the extent of the duty of fidelity, the fiduciary duty, you've got to have a look at the autonomy that the employee has, the control that they have, the influence that they have, the degree to which they are entrusted with making decisions on behalf of the business and controlling property, and controlling information, having access to the information and using the information. And that can give rise to a fiduciary duty. Now, the reason why I'm talking about fiduciary duties is that if you've got it, then a fiduciary duty will extend beyond the termination of employment. So it can be quite important. It can be quite an important distinction to have. And so it's something that you would be wanting to exploit or use in the absence of specific clauses that deal with these things. Obviously, we're going to move along to the specific clauses and the specific ways in which we want to try to address these issues. We don't want to rely on fidelity duties. We don't want to rely on fiduciary duties, unless, of course, they're a statutory director, then it can be quite useful. But we want to have specific contractual clauses, but this is really your backstop. This is the, if you don't have that, then what do you have? So as you can see here, so when this is actually having a look specifically at confidential information. So in the absence of a specific contractual clause that deals with confidential information, there is still an implied duty of fidelity in relation to that confidential information. And this can be quite useful, particularly where you've got confidential information which can even be available or accessible or known by more junior employees in the organisation. And so when we have a look at confidential information, well, what is confidential information? How do we identify confidential information? And these two bullet points, so they sort of begin to help us here, but where it is evident that the information is confidential. You know, everyone knows that it's confidential. It's clear that it's confidential. It would be useful to others. It would be useful to competitors. That would then be confidential information. And obviously that's going to create an obligation of confidence on the part of the employee. If it's obvious that the information is confidential, or alternatively, if it may not be obvious, but the employee is told that it's confidential, then of course they should be keeping that information confidential. Now, you'll also see at the bottom here, we've got an additional piece of legislation which has come in the last couple of years. So this is the Trade Secrets Enforcement Regulations. Now, this is a piece of legislation that has emanated from Europe, a Trade Secrets Directive, and because it's dealing with trade secrets, it's actually drawn far more narrowly than just simply defining confidential information. We're looking at a much higher level. So we're looking at trade secrets here rather than just simply information that you would call confidential. So it's got to have, in terms of what is a trade secret? Trade secret is something that has got to have commercial value. And it's got commercial value because it is secret, because it isn't known by others. I mean, putting it at a very basic level, for those of you that might watch the Greg Wallace program Inside the Factory, you might see that when he goes in and he sees that, the making of Jaffa cakes or soup or whatever, all of these sort of day-to-day products that we eat, that often he then gets to the stage where he then says, oh, so what's in this ingredient? And they go, well, I can't tell you that. And so, of course, something like that would be a trade secret. It doesn't have to be actually labeled as confidential information. Everyone just simply knows that that is a trade secret. And that would be covered by these regulations, which then provides a separate route of enforcement under it. Again, we're looking at injunctions and so on and so forth, which I'll get to a little bit later on towards the end of this session. But it does mean, again, that if you haven't got specific clauses within the contract, it isn't a case that you just simply shrug your shoulders and go, oh, well, we can't do anything about it, because you potentially can. And you just need to bear in mind the fact that you can potentially take action even though you might not have what you think would be required in the contract to actually provide for that. So when we have a look at the duty of fidelity again, so can employees prepare to compete whilst in employment with you? So this is one of the issues. So we're not actually looking at the post-termination restrictions themselves in terms of the wanting to prevent something happening after employment. This is about dealing with them whilst they are an employee, because as I said a couple of slides ago, that largely speaking, the duty of fidelity only applies during employment, and it generally ceases at the point of termination. So you can't, in the absence of a post-termination restriction, you can't actually prevent somebody going and working for the competition, but what can you do to prevent them from taking all of those preparatory steps whilst they are in employment with you? Now, in terms of the general rule, so in the absence of post-termination restrictions, as I said, employees are free to compete after termination. There's nothing stopping them doing that, generally speaking. But of course, if somebody is going to do that, then it's absolutely natural for them to prepare for that competition before leaving employment. So then the question is, to what extent could that be a breach of this duty of fidelity? And so what we've got here is I've sort of lifted a quote from a case, which is trying to, it's all to do with balance. And you'll see that this is something that runs through even when we get to the post-termination restrictions, it's all about balance. The freedom of the employee to prepare for competition whilst also providing some protection for the employer, albeit that courts are generally not going to be that keen on providing a huge amount of protection for the employer if the employer hasn't actually written that clause in the contract itself. But as you can see that from this quote here, that the law will always look favourably upon the efforts of employees to advance themselves, provided that they don't steal or use secrets of their former employer. Okay, so the courts will generally take a fairly, let's say, fair attitude to preparations that employees might take to prepare. But when we look at what they can do and what they can't do, so what they can't do, unsurprisingly, is they can't take preparatory steps in your time, in the employer's time. They can't be soliciting customers whilst they are an employee of yours. They can't entertain offers from your customers. They can't orchestrate team moves by offering work to others whilst they are still an employee. And they cannot take or use confidential information. Okay, so those are the sorts of things that they can't do. What they can do is look for work with a company that's in competition with them. Of course they can. In the absence of post-termination restrictions, they can do that. Even if there are post-termination restrictions, then they can carry on looking for work with a company that's in competition, but whether, in fact, if they were to accept an offer, and whether you could then enforce post-termination restrictions is, of course, slightly different. They can also tell the employer that they intend to compete, and this can be quite a contentious one. So if you know that the employee is going to be competing with you in the future, and they tell you, then what can you do about it? Well, again, without any restrictions in place and without, say, for example, a garden leave clause in place, which we'll turn to in a second, there's actually little that you can do about it as long as they are not breaching their general duty of fidelity. You're obviously wanting perhaps to keep a closer eye on them, but then if you are keeping a closer eye on them, you've then got to begin to be quite careful, because what you don't want to do is to get into a situation, which I'll turn to a little bit later in one of the other slides, but essentially you don't want to be acting in a way where, because you know they're going to be competing with you, that you then just begin to undermine the mutual trust and confidence in the relationship. You begin to monitor what they're doing, because then we can get into constructive dismissal situations. But I'll deal with that in a little bit more detail later on. Now, what you can do, again, this is in the absence of proper confidential information clauses and proper post-termination restriction clauses, is within the contract itself, what you do want, and I'm sure a lot of you will have this in your contracts anyway, but you do want to define the role and provide for flexibility. You do want to specify what the hours are, what the contracted hours are, so that we can see what is your time and what is spare time. You may want to put a ban on certain activities outside of work. So this is about outside employment, and certainly this is something that has come up because of furlough, of course, over recent weeks, because employees that are being furloughed, to what extent can they go and get work elsewhere? Now, under the furlough scheme, they've said that you can go and get work elsewhere, but of course, under the contract of employment, it might be that you don't want them to go and work elsewhere, or particularly you don't want them to go and work for somebody that might give rise to a bit of a conflict situation. So that then helps you address that as well. You might want to provide a clause that provides a positive obligation to report the disclosure of confidential information. And you'll want to define what your property is, so that you can, again, it provides greater scope for you then to challenge the employee about the use of that information and about particular retention of that information after employment. So that was a look at what we can do in the absence of specific clauses. Now let's begin to have a look at what is our toolkit? What can we use? What can we put in contracts that is actually going to enable us to begin to take control and provide protection to the employer? Now, the first one I'm going to address is garden leave. Now, I know I said that I wasn't going to be sending you a big pack of information and it all varies from case to case. Well, garden leave is a little bit different. We can be a little bit more sort of template driven on the example on a clause for garden leave. So as you can see here, I obviously don't expect you to read all of this. You'll get it in the slide pack when I send it out afterwards. But what this does is it essentially provides you with the opportunity to send someone home, for them not to undertake work for you, for them not to contact your customers, perhaps even for them to not contact any of your employees as well, consultants, suppliers, etc., etc. So it essentially allows you to put the individual at arm's length. It gives you some breathing space. It allows you to bring the replacement in for their job, to allow them to develop the relationships that they need to develop, so that then, say 3 months down the line, or if it's a longer period of notice, perhaps 6 months down the line, when that employee is then released from their contract of employment and they then go and work for a competitor, perhaps, or they set up in competition with you and they're trying to go out and get your customers, that actually what you've been able to do is you've had that breathing space. You've been able to ensure that those relationships have been protected with your customers. Okay, so that's the purpose of the garden leave, and it can really work very effectively, particularly where somebody is in a customer-facing role. Now, the final point on this slide is where we're having a look at, well, does it actually need to be expressly set out in the contract? If we don't have a garden leave clause, can we just do it? Well, you can, yes, sometimes you can. You have to be a little bit careful, and there are a couple of issues. First of all, if you place somebody on garden leave, then there is an argument, perhaps, that the employee has a right to work. I'm sorry, when I'm saying putting them on garden leave without the express right to do so. And so when you're doing that, then if there is an argument that perhaps they have the right to work and you're preventing them by putting them on garden leave to work, then that can be a breach of contract. And of course, if it's a breach of contract, then that's going to be a fundamental breach of contract that then entitles them to resign, which then means, of course, that actually you might be cutting off your nose to spite your face, because then the individual is then going to go immediately out there into the marketplace and compete with you at a much earlier stage than might otherwise have been the case. Okay, so that's one of the problems that we've got with an implied garden leave clause, or when I say an implied garden leave clause, essentially just doing it when there isn't an express clause in the contract. Now, there has been a case a few years ago, 2008 case, SG&R Valuation Service, which does indicate that in some instances you can imply that there is a garden leave clause in the contract, therefore entitling you to place senior employees on garden leave in the absence of a clause, an express right to be able to do so. Now, that case, whilst it said that there could be circumstances, it is going to depend upon the circumstances on a case-by-case basis, and I know that that might seem like a lazy lawyer's way of saying that, well, it just depends, doesn't it? But in this particular case, the court was influenced by a misappropriation of confidential information by the directors who were leaving, and the directors were leaving to set up in competition. There were no post-termination restrictions, and so the organisation needed to put them on garden leave. Didn't have the express right to do it, but did it in any case in order to protect the business. And in those particular instances, that was found to be okay. It's a slightly dangerous route to take sometimes, but also in other instances, you might not have anything to lose. So again, just simply because you don't have the clause there, don't rule it out, is what I'm saying. Now, moving on to confidential information. So confidential information is a problem to the extent that, well, how do you define it? How do you control it? And in particular, given the way that information is now so much more easily accessible, you know, we've all got, a large number of us now have mobile devices, access to clouds. You know, we might be storing things on our hard drive, storing things in personal cloud systems on personal phones, etc. In a way where before the advent of all of this technology, it was perhaps easier for employers to be able to control the movement of their information. So on that basis, we need to then be able to define, well, what is it that we can protect? What is it we can ring fence and actually say with some degree of certainty that this is our information and you cannot use it? And to what extent can information be used by the employee? Now, so we've got this sort of graduated differentials of different types of information. So trade secrets, well, I actually indicated that there's some legislation that protects trade secrets. So of course trade secrets can be protected. And as I said before, you know, in terms of how do we define trade secrets and you know, what is it that they represent? Like I said, it's something that is secret. It's something that would be of value to others. And so you can protect that information. Confidential information, moving on to the second one. You can protect confidential information. Of course you can. But then the problem that we then get into here is about, well, to what extent can you protect confidential information, and to what extent has information that has become part of the employee's general knowledge and this information you can't protect, or it's far more difficult to protect. And so we do have this blurred boundary, this grey area between confidential information that you can protect and information that has become part of the employee's general knowledge, which you cannot protect. Okay, so that's really where we have difficulty in this area, and that's why on the left-hand side of the slide I've mentioned that, you know, this is business information versus confidential information. So business information will become part of the employee's general knowledge, but then to what extent can we then show that some of that business information is in fact confidential information? It's not just general knowledge, it's specific knowledge, it's specific information, it's confidential information. Now, of course, one of the ways in which we do that is by clearly identifying within a contractual clause what is confidential information and what we do intend to protect as a result. Oh, sorry, going back a slide. I missed the final bullet point. I know it might seem fairly obvious, but the publicly available information. So if information is out in the public domain, you cannot protect it. So again, a slightly trite example, but Wagamamas have published their chicken katsu recipe online as part of the you know, general public relations in a period of lockdown. Everyone still wants their Wagamama chicken katsu curry, so they have released this confidential information. They've released their trade secret about how you make the chicken katsu sauce, and they've made it publicly available. So that's no longer a trade secret. It's no longer confidential information. That can't be protected anymore. So what about in practice? So what are we looking at when we're actually looking at something in practice? So when we're looking at this grey area, so because of course employees use confidential information during employment, and as a result of that, that confidential information can remain in their heads. But to what extent, just simply because it's in their head, does it mean that it's not confidential information and that it's become, as you see here from this example, you know, quite an old example. Lots of these cases are sometimes quite old. When they're looking at this grey area between confidential information and what is general skill and knowledge, that they talk about confidential information being something that can be traced to a particular source and not something which has become so completely merged in the mind of the person. And so that's what we're looking at here. It's difficult. And this is why when we're having a look at, say, for example, template confidential information clauses, yes, of course, there are the sort of standard things that perhaps that you'd be wanting to include in there. But from business to business and role to role, we should be changing the clauses and identifying what the source of this information is. And if we identify in the clause what the source of the information is, then that means we're going to be far more able to identify it as confidential information which can be protected, rather than something which has just become so completely merged in the mind of the person, which therefore means that it can't be protected. So that's why careful and accurate drafting, rather than just simply a derivative from a template, is so important. And so when we have a look at those clauses themselves, so what we need to do is we need to identify, well, what are our trade secrets? What is our confidential information? We need to sit down and we need to really have a look at it. And certainly if you're wanting these clauses drafted for you, then what we'd be wanting to do for you, or obviously you perhaps doing the legwork on this, is to be talking to the appropriate manager, talking to the person who knows the detail of this job, who knows what's required, that knows the information that is important. And then, of course, we then look into, well, how long does it need protecting for? It actually can be for quite a long time. So this, again, is then where we get into the myths of protection for 6 months post-termination. And you see that in quite a lot of clauses, less so in confidential information clauses. Sometimes we just see the clauses that just say that it's going to be protected forever. And you can do that. It's protected for as long as it is confidential. A trade secret, for example, I mean, if we have a look at the recipe for Marmite, Marmite's been around for years. And so the confidential nature of that trade secret, the recipe for Marmite, isn't something that you need to lock down for 6 months or 12 months or 2 years post-termination of employment. You actually want to lock it down forever, and you've got justification for doing so. So again, some information that might not be the case for, some information that will be the case for. As I said before, you don't want to rely solely on the duty of fidelity that we talked about before. You want to draft your specific clauses. And actually, confidential information clauses are particularly helpful and particularly useful for the more junior employees in your organisation. So again, sometimes what we see within some contracts is that companies might focus in on only including the confidential information clauses where they've then also got post-termination restrictions in place. But actually, it's a sort of graduated process or a graduated strategy that you want to use. You want to use confidential information, perhaps for more junior employees, where the post-termination restrictions won't be in the contract because they're not going to be enforceable, or they perhaps won't be enforceable, and perhaps won't be reasonable. But it will be reasonable to have the confidential information clauses within that. So it's not a case of always having confidential information and post-termination restrictions in there. It is getting the right clauses within the contract, and they are very useful for, as I said, for when you're using it with junior employees. So that's confidential information. So now we're getting into the restrictive covenants and the restraint of trade clauses in the final section, or the final half of the second half, not final half, second half of the webinar. As I said, if you've got any questions, please do fire them in, and we'll make sure that hopefully we get to answer them as we go through. Now, restrictive covenants and restraint of trade. So, of course, starting position. I say of course. It's not necessarily of course, but the starting position is that these are unenforceable. So essentially what you've got to do as an employer is to be able to persuade a court that they are enforceable. The burden is on you as an employer to be able to show that it's an enforceable restriction, a fair restriction, a reasonable restriction. And so you've got to be able to prove that it's reasonable to restrain the ability of that individual to choose who to work for or how they work if they're, for example, setting up in competition with you. So you've got to identify what your legitimate interests are, because that's all you're entitled to protect, your legitimate interests, not just interests generally. And then once you've identified what those legitimate interests are, the steps that you're entitled to take to protect them is only as is reasonably necessary. So you can't throw the kitchen sink at it to then protect those legitimate interests. You should only be going as far as is reasonable to do so in the circumstances. And of course, we then get the public policy issue here, which is all to do with that, you're not simply allowed to prevent competition for competition's sake. What you are entitled to do is to prevent somebody else from getting an unfair advantage. So you're not allowed to just simply identify those companies, for example, that you don't want your employees to go and work for. Rather, what you would be doing is you'd be saying, right, we don't want you to go and work for these companies because you've got access to this confidential information, because you know X, Y, and Z. And for that reason, if you were to go there, that would give them an unfair advantage over us. And so for that reason, it is reasonably appropriate, it is reasonably necessary for us to be able to protect those interests. So that's the sort of thought process that you need to go through when you're having a look at your restrictive covenants and how you're going to draft them, and to what extent you want to provide that protection. Now, reasonableness is an absolute key in relation to this. So how long is it reasonable to protect that interest for, to prevent the unfair advantage? Now, there is a relatively lazy rule of thumb that everyone seems to put in 6 months. But 6 months is a little bit of a myth. Simply because it's more than 6 months does not mean that it's unreasonable. But also, simply because it is 6 months doesn't mean that it is reasonable, because it's all about what is it that you're intending to protect. What is it? What unfair advantage are you preventing from taking place, and how long does that need in the circumstances that you're in? So you've got to be a little bit more analytical than just simply putting 6 months in there. I'll get on to the sort of the factors that we need to take into account. One of the other things that the courts will do as well is they'll have a look about whether there is a public interest in having competition in this area. So, I mean, the example that I've given here, the basic solution and SANS case, is actually it's a leaves on the line case. So it's all to do with the development of technology in relation to removing tree leaves from the railway line. And this person was moving to a competitor. Well, actually, what the court said was that, well, this is actually very healthy. There is a public interest in having greater competition in this area to ensure that the leaves can be removed from the line, because we want to be able to provide a good public transport system. So in fact, in those instances, it wasn't reasonable for that protection to be in place. And then, even if the covenant, the restriction, is held to be reasonable, the court will then decide whether the injunctive relief, and I'll get on to injunctive relief at the end of this when we're having a look at enforcement, but the injunctive relief that you are seeking should be granted. Because simply because they hold that it's reasonable doesn't mean that they are going to provide that injunctive relief that you're seeking. Because actually, once we then get to trial, they're going to have a look at the reasonableness at the time of the trial. Okay, so that's where we're having a look at the reasonableness. And of course, one of the reasons that we've got to be looking at the reasonableness of the clause is because, again, what the court is doing is this whole balancing exercise. So they're balancing the fairness on the departing employee, the right of the departing employee, the freedom of movement to earn a living, whilst also providing appropriate protection to businesses. And so for this reason, it's often unusual to see a restriction to be upheld against junior employees. That's not to say that they won't be. As I said, you're more likely to be able to enforce a confidentiality clause against a junior employee than you are going to in relation to the restrictive covenants. And also the other thing that we've got to do when we're having a look at how long the length of the restriction is in place, we also need to be taking into account the garden leave. Now, of course, we had a look at garden leave earlier. So what the courts will often do is they'll add these two periods together. So if you've got a 6-month notice period in someone's contract and you then exercise a right to put them on garden leave, you're taking them out of the equation for 6 months already. So therefore, to then add another 6 months on the end of that in relation to then preventing them working for a competitor, for example, that full 12 months might not be reasonable. And so you need to take that into account. It's not simply a case of these separate clauses being taken in isolation of one another. So you need to get these clauses correctly drafted. In order to be able to improve the enforceability of them, then these are the sorts of things you need to think about. So who are the customers? So where is it, what customers do you want to ensure that they're not going to try to take from you? What is the order cycle? So again, this is an important factor when we're having a look at the length of the restrictions. So if an order cycle, if the contracts are renewed on an annual basis, it could well be that a 6-month restriction just simply is pointless, because for an awful lot of the customers during that 6-month period where the restrictions are in place, the customers are going to be tied up in a contract with the ex-employer or with you in any event. And so it's not going to be until the renewal time that then it becomes key. So that's another factor that you need to take into account. And then what the courts then do is, well, to what extent do your customers use other suppliers anyway? How many suppliers are there in the industry? How much movement is there in this industry? To what extent does the employee have direct contact with customers? And if so, who? What trade secrets do they have? What confidential information are they privy to? And how long does that confidential information last before becoming obsolete? These are all the things that we need to have a think about to ensure that we are drafting the clauses in the correct way to provide you with the greatest protection. Now, of course, one of the things, this takes time, and you're doing this in order to improve the enforceability of the clause, to ensure that the clauses are reasonable and reliable and enforceable. But of course, you might not be too worried about that. You might just simply be wanting to have the restrictive covenants in place to try to dissuade the majority of employees who have them in their contracts from going and joining competitors or setting up in competition. But you accept that actually it's going to happen and you're not too worried about it. As long as you can persuade, say, 70 or 80% of your employees not to, then the clause has done its job. And in which case you might want to take a far more relaxed attitude to the drafting of the clause, because you then might think that, well, we're not going to rely on it in any event. We're not going to go down the litigation route. And so therefore we are relaxed about it. I mean, for example, I drafted a clause for a client a few months ago, and they said that they wanted a 2-year restriction in place. Now, on the balance of, we're having a look at these factors of the customers and the order cycle, etc., there was no way that a 2-year restriction was ever going to be enforceable, but they simply just wanted to make the employee think that it might be enforceable, to try to dissuade them from competing. So again, that's the balance that you need to take into account when you're drafting these clauses. But the one word of warning that I would give you is that if you're drafting a clause which is clearly unenforceable, then the individual employee is never going to consider themselves bound by it, and they're just going to act in breach of it in any event. So what we're now going to do is I'm just going to essentially just sort of remind you about what is in your toolkit in relation to these restrictive covenants. So first of all, we've got non-solicitation. So non-solicitation. So this is generally the preferred way of trying to protect the customer relationships. So it's all about preventing your ex-employees from trying to take your your customers or clients from you. So this includes, enticing, tempting, luring, persuading customers to move from you and across to the new employer. Now, this can be quite tricky because, of course, what we're getting into here is, well, what about the evidence? How do you, in order to enforce this non-solicitation, we need to have some evidence that, in fact, solicitation has taken place. And certainly, one of the sort of ways that people get around this is just by ensuring that there is no record of any communication between the employee who's doing the soliciting, and rather they might even get the customer to send them an email to say, oh, I'm just wondering if if we were to think of moving across to you, etc. So that it makes it look like there is no step that they have taken to actually entice or lure or persuade anyone across. But as you can see here, that isn't a given that means that it's unenforceable, because the employee doesn't have to make the first move. But this is just a difficult area in relation to evidence. So enforcement is difficult because of evidence. So then we can consider what's called a non-dealing clause that then tries to deal with that. Now, obviously, I'll talk about non-dealing in a moment. But when we actually have a look at the non-solicitation clause itself, so do we limit it to those that they had contact with during a specified period before termination? Well, not always. Don't necessarily have to. Obviously, if you do, then that restricts the scope of it, and so therefore is going to make it more reasonable. But again, what you're going to be doing is, well, in terms of the enforceability of this, well, what influence do they have over customers? If they don't have very secure relationships, if they have fragile relationships with customers, I would say whether this is the actual employee themselves or whether it's the business has fragile relationships in reality, then the non-solicitation clause is probably going to be unenforceable. But again, you're going to be having a look at the level of seniority in the business, the extent of the role that they take in securing new business, keeping that new business, and so those again are the factors that you take into consideration. You can include prospective customers sometimes, but that's more difficult. But again, if you can actually identify who those prospective customers are, and particularly where there is a long lead time into trying to get a new customer, if there's a lot of wooing that goes on, a lot of tempting and luring that goes on to get the new customer in place, then that's going to be easier for you to protect. Okay, so that's non-solicitation. When we have a look at non-poaching, so non-poaching, so this is the essentially don't try and nick our staff clause. So this prevents the solicitation of other employees. So the non-solicitation one that we had a look at just now is looking at the tempting and luring of customers. This one is looking at the tempting and luring of your employees, because of course you want to be able to have a stable workforce. If one person leaves your team, then that's something, particularly again with the use of perhaps a garden leave clause, you can manage. You can introduce other members of the team to those customers, and you can go through this process of providing stability for the customer and protecting those relationships. But if the employee is leaving and then is then taking another couple of members of the team with them, then that can destabilize the team, destabilize those customer relationships, and so therefore you are entitled to take steps to protect that through a non-poaching clause. But again, when we have a look at the how reasonable it is to have such a clause, and for how long that clause should be in place for, is going to depend upon the level of influence that person has. So what influence do they have over other employees? How long is that influence going to last? Again, if they're a senior employee, then it's likely that they're going to be able to make promises and have a stronger influence over the more junior members of staff. But this is then when we get to the bottom point here, where we're looking at team moves clauses often don't work. I'm saying often don't work again, that's not to say that you shouldn't have them, that we can't put them in there and that we can't try to prevent this sort of thing from happening. But team moves are a bit more difficult because, of course, team moves are often people of the same level. So there isn't so much influence there. And so therefore it's more difficult to protect. And of course, we then get to the whole public policy point, which is that, well, the courts are going to be reluctant to get into an argument between the employer and the ex-employee, where in fact the result of that is actually preventing the third party, the other person, the one who has this other offer of employment perhaps, who is being poached, to choose where to work. Why shouldn't they be entitled to choose where to work? So that's the public policy issue that then, and often the difficult conundrum that the courts have to deal with when they're addressing these issues. When we have a look at it in practice, so just a couple of cases. So Alliance Paper Group case, so an injunction to prevent a managing director employing or enticing those who were employed in a senior capacity during the last 6 months of service. So as you can see, there is a fairly heavy restriction there in terms of the scope of that clause. It's not just a broad, you can't take anyone, it's only those who were employed in a senior capacity and in the last 6 months of his service. That was enforceable and an injunction was provided. Then the next one then shows that whilst the Alliance Paper Group one was enforceable because of the restrictive nature of it, the Hydra PLC case, it enforced a non-poaching clause that applied to all employees of a company where that company only employed 12 employees. Again, the need for stability when it's a small organisation is that much greater. The effect of a couple of people leaving is that much greater. And so again, very much a case-by-case approach needs to be taken. Now, the non-dealing clause. Now, I mentioned this when I was talking about the non-solicitation clause. So the non-dealing clause sort of deals with the problems that we have with non-solicitation. So where non-solicitation, perhaps where we don't have the evidence about the poaching, the luring, the tempting that has gone on in relation to taking one of our customers from us, what the non-dealing clause does is it actually just simply says you can't deal with any of our customers. It doesn't matter who it is that approached who. It doesn't matter whether you asked to do work or you tried to, or you approached them or you didn't approach them, etc. Now, so you use it where the non-solicitation clause is difficult to define and police, but it does really broaden the restriction. And again, when we have a look at the rights of the third party, so the rights of the third party to choose who they deal with, who they want to deliver their services. So that's again the conundrum that the court is going to have to deal with when they're actually having a look at the enforceability of a non-dealing clause. If there is a strong personal connection between the individual and the customer, then it's more likely to be enforced. Okay, so more difficult to enforce the non-dealing clauses, but it can happen. Now, for example, again, having a look at the reality. So in this case, these marine reinsurance brokers, so there was a non-dealing clause that could be enforced because of the personal qualities that might lead clients to gravitate towards them. So it's all to do with that relationship that they had. Okay, and where there is a very strong relationship and long-standing relationship between the individual and the customers, or particular customers, then it's more likely you're going to be able to enforce non-dealing clause. And again, just another couple of examples for you there of instances where it has been upheld. So a 2-year non-dealing restriction upheld against ex-director of a firm of shop fitters was enforceable despite the fact that some clients insisted they had no intention of dealing any longer with the ex-employer. Okay, so again, coming down to those relationships and the damage that is being done by the departing employee. And again, Beckett Investment Manager, again, looking at the significant degree of client loyalty. So where you're in that sort of situation of a lot of client loyalty, strong personal relationships, then non-dealing clause might be a way to go in order to try to protect yourself. Now, I'm conscious of the fact that we've only got 5 minutes left in the session, so it might be that I overrun just by a few moments just to get through the final few slides, but I will try not to do so by too much at all. So please bear with me while we just go through the latest one. So non-competition. So this, of course, is that you can't go and work for our competitor. So this is often the most powerful tool in your toolkit of restrictions, but because it's the most powerful one, it's traditionally harder to enforce. So really, your first line of defense should be your confidentiality clauses and your non-solicitation clauses. And it's only where where you can't get the safeguards that you need from those two clauses that you then rely on the non-competition clause, because your non-competition clause it's not quite a sledgehammer to crack a nut, but the courts are going to be far more reluctant to enforce a clause like this than they would be the confidentiality and non-solicitation clauses. But again, trying to put it into reality and put it into practice so you can see why it's simply necessary to have a non-competition clause. So this dealt with an ex-managing director who found Mr. Thomas, who had sensitive confidential information which would be helpful to a competitor he was going to work for when devising a strategy to undercut his former employer. So solicitation was never on the cards. Mr. Thomas is never going to go out and try to solicit customers. He's never going to be dealing with customers. So your non-solicitation and non-dealing clauses just simply don't work where you've got someone of a level where they're going off to join a competitor to work in a strategic way, not get their hands dirty, so to speak. So these clauses can work, and in some instances, in conjunction obviously with the confidentiality clauses, are entirely appropriate and required. But again, you just need to have a think about the circumstances in each instance. So those are all the different sorts of restrictions that you can put in place. When we're then having a look at the length of them, I know I've sort of talked generally about the length of the restrictions and about the slight myth of the fact that 6 months is reasonable and anything over 6 months isn't reasonable. These are the factors to take into account. So how long is it before the departing employee's replacement is able to settle in and cement relationships? That's what the garden leave clause can be used for quite reliably. What is the shelf life of your confidential information? As I said, for example, the Marmite recipe, the shelf life of that is incredibly long. Some of you might not wish it to be, but it is. But in other instances, the shelf life of the confidential information in a fast-moving environment is going to be obsolete within 3 months, 6 months, something like that. The frequency of contact with clients, the longevity of the customer connections, what turnover is there in the marketplace in terms of customers, what turnover is there of staff, what's the length of employees' notice periods and the state of the recruitment market, what's the industry standard. So all of this needs to be taken into account when you're actually trying to define what the length of the restrictions are. And so also, what is that order cycle? Because again, if the order cycle is 12 months, if you've got annual contracts or biannual contracts, something like that, then again, that's going to allow some of the clauses. And again, you're not necessarily going to have the same length of restriction in place for different clauses. So you're going to perhaps have you would have a longer clause in relation to confidential information, but your non-solicitation clause might be shorter. But your non-solicitation clause might be a couple of years, if in fact you've got long contracts with your customers and established customers. So again, it's sitting down, speaking to the people in your sales, in your marketing and your commercial teams about what sort of damage might be done, because it's once you then can assess what damage can be done, you can identify what your legitimate interest is and then take the reasonable steps to protect them. And finally, how do you enforce? Well, yes, you can litigate. It's expensive. It's high cost, it's high risk, it's all hands on deck. You've got to act very quickly, and it's a lot of hard work in a short space of time. But if you've got a legitimate business interest to protect, it is going to cost you a lot of money if you don't do anything, then you probably don't have a huge amount of choice. If you're going to go down that route, then obviously we can help you, but you also need a specialist barrister on the team. This is a specialist area of law, and you need to make sure that you have the right people on your side to fight the fight for you. But before you get to that stage, you might want to consider undertakings instead of litigation, because as I said, litigation is very expensive. So what you can do is obtain undertakings from the ex-employee about what they shall and shan't do, and about what information they have and haven't got. And then if, of course, those undertakings are breached in the future, then it doesn't mean you can't then go and litigate, because you can. And in fact, it probably gives you a stronger hand if you were to do so. But it is an expensive route to go down. And you need to be aware of that before you do so. Now, one last point that I just want to make before we wrap up is in relation to the risk of constructive dismissal. I mentioned it briefly when we were talking about when I was talking about duty of fidelity. But where somebody is still in employment and we know that perhaps they're going to be joining a competitor at some point, we've got to be careful not to act in a way which is going to undermine the mutual trust and confidence. That we're not going to give an excuse for the employee to consider the contract breach. We're not going to be overly monitoring. We might want to increase the level of monitoring, but we don't want to be acting in a way that then breaches mutual trust and confidence. Because if we do, and we have all of these restrictions in place in their contract, if they resign because of a breach of contract on our part, because of the way that we've behaved, then all of those post-termination restrictions then fall away. And all of that work you've done is for nothing. So we do need to be careful about how we behave during that period of time. Okay, as a little example there, I won't go through the detail of the facts of that now. You can have a little read of it at a later point, and in fact, you Google it if you so wish to do so. Okay, so that concludes that session. I do hope that you found that useful. Obviously, if you do want to have some help with drafting your contracts, drafting post-termination restrictions or confidentiality clauses, anything like that, then we can do so. Just get in touch. If you want to keep up to date on our mailing list, then please do just email me to subscribe to the mailing list. Also do just keep an eye on LinkedIn and Twitter as well, because I'm also posting updates there. Keep an eye now on our YouTube channel, because I'm posting some short videos on there, and in fact this live webinar will also be available there as well in due course. And of course, if you want any help in relation to support packages, we offer a range of support packages, so it's not simply a case of just engaging with us on an hourly basis. You can have a package that's designed for you and for what you need. So do get in touch with us if you want to have one of those packages put in place. But otherwise, that's the end of the session. Thank you very much. Take care, everyone, and no doubt see you at some point soon when we do another one of these webinars, which won't be too far off in the future. Okay, lovely. Thanks very much. Bye.